The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, April 13th, 2016 are currently trading with gold at $1,246.13 an ounce, silver $16.29 an ounce, Texas crude $42.17 a barrel, and Bitcoin is currently sitting at about 426 U.S. currency. Today in history, the year 1970, the Apollo 13 astronauts announced, "Houston, we've got a problem," as a result of a beach-built oxygen tank exploding en route to the moon. The beginning of the Apollo 13 crisis was 46 years ago, today in history. In recent news, more than 400 protesters were arrested last Monday outside of the U.S. Capitol from an organization called Democracy Spring, which is seeking to remove special interests from politics and raise awareness for change on restrictive voter identification laws. The demonstration resulted in arrest for what U.S. Capitol Police deemed unlawful demonstration activity, such as crowding and obstruction. Apparently, the protesters were sitting on the stairs of the east front of Capitol Hill. Democracy Spring said on their website that the protest was held to demand Congress take immediate action to end the corruption of big money in our politics and ensure free and fair elections. Peter Callahan, the group's communication coordinator, stated that, quote, "We see populism on the rise on both sides of the spectrum. Americans are sick and tired of their politicians being bought and paid for. Organizers are vowing to continue the demonstration every day for the duration of a week." The Pentagon declared today that the first phase of military operations against the Islamic State in Iraq and Syria are now over, and that the second phase is being implemented. Colonel Steve Warren, the spokesman for the U.S.-led coalition fighting ISIS, stated that Phase 2 is aimed at dismantling this enemy, while Phase 3 is ultimately the defeat of ISIS. Success in the first phase included the recapture of about 40% of the territory ISIS once held and the annihilation of key leaders and revenue sources. The second phase, now underway, is focusing on fragmenting ISIS and liberating key territories under their control, like taking back Mosul in Iraq and isolating Raqqa in Syria. The Lone Star Lowdown is currently looking for sponsors. If you have a product or a service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This has been Rick Rohde with your Lowdown for April 13th, 2016.
Okay, howdy, this is Randy Kelton with U of L Radio on this Friday, the 15th day of April 2014. It's File Your Tax Day, but we're not even going to talk about that because it'll just give me a headache. We will have the phones all night. This is our 4-hour info marathon, so if you have a question or a comment, give us a call, 512-646-1984. And we're going to start out talking about some of the things going on in Parker County. We had a woman there who was driving on an invalid license. She addressed the right to travel, and at the day of trial, the prosecutor came in and filed a motion in limine. Now, he had a duty to file that 7 days before trial, but he filed it the last day because the woman was representing herself pro se. And she objected to it anyway. The judge overruled, and the motion in limine forbade her to bring a defense of right to travel. Now, you can overrule a defense, but you can't deny someone the right to bring a defense. And he actually said that it might unduly influence the jury. Well, a legal argument's intended to influence the jury. So they denied her in the right to defend herself in court. And then the judge, in his charge to the jury, defined traveling and a motor vehicle in a way that's not defined in the code. So we're going to go after them, and they convicted her, and they gave her 90 days. They put her in jail, and the jailers wouldn't allow her to file a notice of appeal. It appeared as though they pulled this garbage on her, and then we're going to try to hold her in jail without access to the court until her 30-day time limit for filing her notice of appeal was up, in order to deny her access to the courts and deny her right to appeal. So her husband listened to the show, and he got a hold of me, and I'm not far from Parker County, so I went down there and danced on him a little bit. And when I asked a sergeant to arrest the assistant warden of the jail for denying her access to the courts, all of a sudden they got that fixed really, really fast. When you stand up to them, when you take them on, they tend to start doing things right, or at least as right as they can. And in this case, I made the accusation to the sergeant, and he refused to take my complaint. He said I'd have to talk to the jailers. And I said, now, wait a minute. The jailers are not certified peace officers. They're just jail guards. They can't take a criminal complaint. You are the sheriff's department. You are the one to take the criminal complaint. Oh, no, you'll have to talk to the jail. So you're refusing to take my complaint, you'll just have to talk to the jail. So within 2 hours from the time I called, the assistant warden had sent her jailers down there with a notice of appeal and put it in her hand, had her sign it, and took it to the court. So the way I read that was that the sergeant on the sheriff's department refused to take my complaint against this person. And then as soon as I hung up, he called this person and conspired with her to try to shield her from prosecution by having her go ahead and give this woman access to the court. Well, the way I read that is shielding from prosecution 3805 Penal Code, obstructing justice 3606 Penal Code, and criminal conspiracy 15.02 Code. So I called down today and talked to a captain, and I'll be filing official oppression, a shielding from prosecution, and obstruction of justice against this sergeant for trying to shield this warden from prosecution. I don't know what they thought, that running down there with this notice of appeal would somehow fix this problem. That's like me, this woman had asked them every day for 20 some odd days for a notice of appeal she could file with the court, and they ignored her, and she filed grievances against them for it every day. And they threatened her and complained about her harassing them with these grievances. But she marked it every day. It's kind of like me running the same red light every morning for a month, and then a policeman pulled me over for it, and I tell him, oh, that's okay. I'll go around the block, and this time I won't run the red light. Well, the first time they didn't give her that form, that bell was already rung, and they can't unring it. And each day when she asked for it and they refused, they rung that bell again. And we'll see how well that works out for them. We do have a caller. We have Erwin from Nevada. So I'm going to go to the phones. Hello, Erwin.
Hi, I was on the call last night and enjoyed the information you gave. One quick question. I filled out on one of the websites from one of your YouTubes, but I can't find it, where they said if you have a problem, briefly describe your information, because I have situations going in 3 different houses. I think it had mortgage in the title. Do you know which one I'm talking about? But one of the sites that you and your colleagues use to advise or help people?
I have no idea which site you're talking about.
Oh, I think, okay, let me see if I can find it. Well, in any event, you were mentioning, the rescission. I mentioned that one on our primary residence, but I did rescissions.
Okay, hold on just a second. Move the mic a little bit away from your mouth. The mic is booming a little bit.
Is that better?
Better.
Right, okay, all right. Yes, I did a couple of rescissions on homes that were deeded to me in Virginia, which is also deed of trust state. I'm not the original borrower, so I want to get that understood up front. However, and one could say it's not a primary residence, more than 3 years and all that, but I've been reading that if they don't respond in 20 days, it doesn't matter how wrong, quote-unquote, the rescission is, that they're kind of done. And plus, there's that situation, they both were in foreclosure at at one time. So you mentioned that, I think, CFR 226, where there's an exception when you're in foreclosure that you can the right to rescind comes back. So
I had a case in New York just a couple of days ago where we had filed the rescission, and I filed a quiet title action based on rescission. And the court came back and they removed it to the federal court, and the federal court will rule against us, of course, no matter what. And they said that the right to rescind does not last forever. It only lasts for 3 years. And I responded, well, that's incorrect. Yes, it does last forever. Once a notice of acceleration has been given, the right to, if you can show more than $35 of undisclosed charges, the right to rescind, renew, reinvigorates, and it lasts forever. There is no limitation on it. So, yes, it does last forever after foreclosure.
I see. Well, one of the things which I did suggested was I filed a notice of interest in real property in the appropriate counties, along with a copy of the rescission, a copy of the certified mailing, and that I contacted them even after that period of time. So that should serve as kind of a...
what that does is take away the trustee's good faith. A trustee cannot be sued so long as the trustee acts in good faith. The Les Pendants, or you're not in California, you did say a notice of preservation of interest.
Notice of interest in real property is what I entitled it.
In California, they don't call it a Les Pendants. Everywhere else that I've been, they call it a Les Pendants. Is this specific to Nevada?
No, I don't think it is. I filed one for the House of Nevada and two for the two houses in Virginia, which is also deed of trust state. And I thought I might become resistant. I've been hearing some people they're not allowing them to file, but the recorders didn't give me any problem at all in any of the three.
Okay. The reason I asked that question is if you try to file a Les Pendants in California, the clerk won't take a Les Pendants. And so far, that was since you used the different term, that's why I was asking the question. Because in California, if you are not an attorney, you have to file a notice of preservation of interest. It's the same thing, but you have to call it something different, or the clerk will kick it out. So in your case, it shouldn't make any difference what you call it, because it is what it is, regardless of what you call it. I just wanted to find out if there was a special distinction in that regard, and I assume there is not.
Right. Well, the interesting thing is, on one of the two Virginia houses, I got a notice of sale. It wasn't even 30 days with a new trustee. And this particular house, there have been no payments made since September of 2008, which I think would qualify it for statute of limitations for Virginia and maybe the UCC, amongst other things.
Okay, hold on. Statute of limitations begins when they file a notice of acceleration.
Yeah, they did in early 2009.
Okay.
No payments made. Yeah. So that was that. But
hold on. Did you file a rescission in that one?
Yeah, I did.
Oh, this is perfect. They're going to claim that your rescission is barred by statute of limitations. Wonderful. You get to claim that their foreclosure is barred by statute of limitations. Well, no, so they can't claim the statute of limitations as a bar on one hand, and then as try to act in violation of them on the other. So that puts you in a good spot.
Well, no, what I did was, as I said, the tenant I had in all those years, he moved out, he trashed the place, it was looking like $7,000 in repair, and I didn't want to try to rent it if that was hanging over. So I didn't do as I'd done before to file anything to stop it. So I got notice that they did indeed foreclose, although it's not recorded in the county as yet. I asked the county why. I guess we're getting a commercial? Sorry.
Yes, I'm going to
commercial
break. Hang on. Randy Kelton, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking to Irvin in Nevada. Okay, we're talking now about the property in Virginia.
Right. They went ahead with a foreclosure despite the recorded rescission. So I am wanting to prepare a wrongful foreclosure suit.
Okay, wait. Hold on. Did they file a trustee's deed in the public record?
Yes, giving me less than 3 weeks.
Okay. File a quiet title action against the trustee's deed. It's easier to challenge the trustee's deed than it is to file a suit for wrongful foreclosure, because the specifics on the filing of the trustee's deed are more critical and more clear than what is or is not a wrongful foreclosure. It will essentially have the same effect. And if did the bank buy it back, or did a third party purchase?
No, but the bank bought it back, and it is not reflected as yet in the county recorder's office. I'm
okay.
The owner, so I called them and said, what's going on? They said it until...
Okay, wait a minute. I made a big mistake. I was too interested in the subject matter, and I have a special announcement. We have a new co-host. Since Steve Skidmore left, I've been needing a co-host. And I get in here and I start talking about these things. I get on these long monologues, and sometimes I'm not sure when I've said enough, when it's time to shut up. And since I'm sitting here talking to the microphone, I'm not always sure when I leave something out, because I know the subject matter really well. So I don't know when I skip over stuff, and I really needed someone as a counterpoint. And in all of the years that I've been doing radio, I've recommended one other person to be on the show, and that was Eddie Craig. And he now does the Monday night show. And when I met this person, I knew immediately she was perfect. She has the talent. She has the charisma. I'd like everyone to meet Yvette Pack. Hello, Yvette. Say hello to everyone.
Hi. How are you doing? Good night.
Okay, we're getting a little bit of lag on your side. Yvette is a physical trainer and a therapeutic massage therapist. She has her own business, 4 kids, stays real busy, but has the personality that she belongs on the radio. So go ahead, Yvette, introduce yourself. Let's see if your lag is cleared out.
Okay. I've been personal training for about 13 years, professionally, and massaging for 4. But I have a lot of background in many different things. And I've done some acting in the past. It's kind of my forte. I love to be in front of people, and I love helping people. So, and when Randy came up to me about this, I jumped on the wagon real fast. And I love what he's doing with this show. I actually have been foreclosed on and lost land that was in my family for 100 years. Story, I won't get into that, but I'm here and I feel what everybody goes through. And I'll tell you, it has been the worst thing that's ever happened to me. So if you're going through foreclosure tonight, just know that I'm on you, and I know what I'm going through.
Okay, wonderful. This is going to be a good argument to what I'm doing, because sometimes it gets difficult. I don't always know what my listener's thinking, and that will be a great counterpoint to let me know when it's time for me to shut up. Okay, Irvin, I'm sorry to interrupt. Okay, where were we?
Yes, by the way, I heard 3/4 of what she said from my end anyway, and it was it's good to hear other people going through, similar situations. But getting back, no, they did not. Nothing is recorded in the county recorder's office. They said until they get proper paperwork from the lender, they can't and won't do anything. I don't know whether the lender noticed the thing that's recorded regarding rescission or what the deal is, but I think that was from the 18th and from last month, and there's still nothing but my name showing in the county recorder's office, so I'm a little reluctant to.
Okay, so you don't know if the bank bought it back or if it went to a third party.
Yeah, the trustee. I called. There's a substitute trustee from Ocwen, who's I think they have their own troubles, to Shell Point. That's a place out of Florida. And I called Shell Point, and they said, yes, the sale took place, and the bank took it back.
Oh, good. Okay. If you're facing foreclosure and it goes to the sale, if the bank buys it back, that's not really such a bad thing. Then you don't have a third party in the mix. If there's a third party in the mix, the first thing you do is sue the third party. And then the third party gets real excited and jumps up and down, and then they sue the bank. But if you don't have a third party, it's oftentimes easier to get the bank to rescind the foreclosure. Rescinding the foreclosure for the bank doesn't cost them anything. So you have a little bit more. You got more you can work with. So, okay. Then, since a third party didn't purchase, then you might want to go for quiet title you can go for quiet title on the deed of trust. And then once the trustee's deed, I would actually wait until the trustee's deed hits the county record. Then you go after the trustee's deed.
And as far as damages?
It's a lot. Well, no, you don't go for damages. You just go for declaratory judgment.
Okay, so it keeps it $75,000, keeps it state, so they won't be able to kick it up, and no value, things of that nature. That's why you're doing that.
No, well, once you sue the bank, they're not going to do anything with the property. When you file the quiet title action, that's kind of a bank shot. The bank knows that you have all kinds of other claims you can make.
Right.
And since you file a quiet title against the deed of trust, they know you're sharpshooting them. And they can fight for the next 2 years on that particular issue. And if they win, you're just going to come back going after another document. You come back and go after the deed of trust. And then when you get done with that one, then you're going to come back for wrongful foreclosure. So in the meantime, always we expect to lose in the end. So the best thing we can hope for is to maneuver the bank into a position to where they will be amenable to coming to the table and making a deal. In the end, do not expect them to ever back down from the lawsuit.
Right.
But they will come to the table and make a deal. So first thing I would do is a quiet title action on the deed of trust. You don't really know if the property has been foreclosed on. All you know is somebody said some blah, blah, blah on the phone. But officially, you don't know anything until that deed of trust hits the record. And as soon as it hits the record, sue the trustee. Or you sue for quiet title as to the deed of trust and you name the trustee. Don't name Aquin, don't name anybody else, just the trustee.
Right. Which is, by the way, it's a two-name law firm, and they have foreclosure services of Virginia LLC. So they got the law firm and some type of LLC, even though they're the resident agents, both of the two.
Well, there should be a human being named as the trustee. The human being is the one you want to sue because that human being, are you in Virginia?
No. That's the problem.
Okay. In that case, if you sue the trustee personally, then it keeps it in the state. But since you're in Nevada, you'll need to sue in the federal court in Nevada. That's going to really give them heartburn.
I thought that since the thing is the venue, would that be the wrong venue there because the dispute is in Virginia?
Venue's where you live. If it's federal, they file it where you're at. Hang on, Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Are you stressed? In our fast-paced world, many of us are, but there's something better than alcohol or big pharma pills, and it could add years to your life. I'm Dr. Catherine Albrecht, and I'll be back with more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
How much is that doggy in the window? Arf, arf. If you're stressed, it's a question you might want to ask. Researchers say companion animals like dogs lower the stress hormone cortisol, and lower stress can lead to a longer, happier life. Pet owners also have significantly lower blood pressure, cholesterol, and triglyceride levels. This can be particularly important for patients recovering from heart attacks. In fact, studies show that pet owners have a much higher one-year heart attack survival rate than those without pets. Dogs may be man's best friend, but they're not the only animals with health benefits. Cats, birds, and even fish can work miracles. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay. How's that? Citizens arrest for Mr. Bush. Citizens arrest for detainee. Well, I need a prosecutor to come and help me. Prosecute them wicked leader, yeah, you see. Them a murderer, liar, them tell me. Them a liar, not tell sweet story.
Okay, we are back. Randy Kelton, Blue of Law Radio. We're talking to Irving in Nevada. Okay, if you sue, you're in Nevada. Normally, venues where the property is.
Yeah.
But if you, the hardest part about doing this is keeping it in the state. Because anytime you sue the lender, he's going to remove it to the federal courts right away. So since you're in Nevada, property's in Virginia, and Aquin's in Florida, you sue in Nevada, where you're at. Then they'll have to hire a lawyer for Nevada, but for them, that's not a big deal because they do that anyway.
Right. I see. Okay. That does make sense. Okay, and the final question is a completely different topic. I was hoping to get your opinion on an unusual situation, Randy. I got a judgment, default judgment against a debt collecting company, which is no longer in business. I found out while they were still in business that they had a bank account at Bank of America. So I took my judgment in a writ to the constable in Las Vegas, and he went to the Bank of America branch, which happened to be a block from his office, and he got the judgment. And this, we're not talking a big change here, $2,200, big deal. And he got the judgment from Bank of America, and I got in the mail from Bank of America, interrogatories to be answered by the garnishee under oath, and they answered a lot of questions themselves. And the constable said they get to hold on to it for 30 days or run it past their legal department. So they signed this on 22nd of July. Okay, remember that date. On the 29th of August, more than a month later, they contacted the constable and said, that check we sent you, don't cash it. We're stopping payment on it because we have the wrong account. So I went to Bank of America. I called them and said, what's that about? And they said, well, we have the wrong account. And I said, isn't Banking 101 that if the constable comes to you and says, I have a judgment against your ABC company at account number 123456, you check those two things and verify they exist? And they didn't really have much to say to that. So I sent them 3 demand letters. Oh, to me, that's kind of like if I go to Walmart and charge $1,000 when I only have $100 on my card, but somehow it magically goes through, and I walk out the store with the merchandise. Bank of America can't go to Walmart and say, Irvin, pull the fast one. I'm sorry about your $1,000 of merchandise. We have to take that money back. But they have to eat it, and they come after me. So
you need to look at law in Las Vegas, because this thing is stopping payment on checks. You really can't do that.
I did. Well,
once they've written you the check, they can't stop payment on it. If they've written it by mistake, then they have to come to you and do something to be able to get their money back. But they can't stop payment on that check.
They didn't stop payment on the check to me. They stopped payment on the check to the constable.
Doesn't matter who they stop payment on the check to. That's your money.
Yeah.
The constable is holding it as a fiduciary. They stop payment on you. So you need to look at the law on stopping payment on the check. If they wrote it on the wrong account, they just need to change the entry in their ledgers. Now, you had plans for that money, and you had already committed that money to your plans, and they took the money back, and they cost you the benefit of the bargain that you were going to have with that money. And it caused you horrible emotional distress.
Yeah, I thought intentional infliction of emotional distress. Well, I'm a senior too, and there's a statute in Nevada. Deceptive trade practices against a senior or disabled person, and it doesn't say how much you can go for damages there. It does for the state. The state can fine them $12,500 per count, but that's for the government. It doesn't do with me. It doesn't say how much I can go for. So is it anything like, can I throw in some things like tortious interference or the NRS thing against seniors, deceptive trade practices, anything like that? Or what charge
Yeah.
I should go for?
Yeah, the fact that they stop payment on the check, that's problematic. If you write a check for services or a product and then you stop payment on the check, the district attorney's going to land on you like a ton of bricks.
I'm sure he will.
So you might talk to the district attorney about that. They wrote the check and then they stopped payment.
Yeah. And I have a screenshot from the constable showing that, by the way, from his computer, where it said, don't cash that check. We're stopping payment on it. So as far as evidence goes, I thought that was pretty good. But that's something I have to file a police report first again, and hope the police will
I would definitely file a police report. Most people don't go after these guys criminally. And I suspect when you start filing police reports against them, if you have a photocopy of the check, see who issued the check. Somebody had to fill out that check and sign it. You file a complaint against whoever's signature's on that check.
Oh, okay. It says, do not take money on this case. They have stopped payment on this check, Emma at Bank of America. And it has a phone number and their law office in Los Angeles. So that's the extent of it.
You know, they can do illegal stuff if nobody calls them on it. So I suspect when you go down and make a formal criminal complaint against them, it's a good chance you'll get a check really, really fast.
All right, but just the amount, because it's been a while. No damages?
Go, you can ask for damages. Good chance they'll give them to you just to get you to go away.
Oh, okay. But the best charge, if I was going to ask them what the charge is, fraud through stopping payment on the check, or
that's generally fraud. But I would have to look specifically at Nevada law to see what Nevada law says about for stop payment.
They mentioned if you don't have the money, it's which obviously is not the case here, but it's not the case that there's a dispute, which I'm sure they're going to put up a dispute and say, well, we have the wrong account. But I don't think that's a viable defense. So
the bank can't make that argument.
I mean, I can see if it was 1 day, but 30 days. I mean, over 30 days, they noticed there was the wrong account.
Here's the law in Nevada. A customer or any person authorized to draw on the account, if there is more than one person, may stop payment of any item drawn on the customer's account or close the account by an order to the bank describing the item or account with reasonable certainty received at the time and in a manner that affords the bank a reasonable opportunity to act on it before the happening of any of the events described in Nevada statutes 104.4303. If the signature of more than one person is required to draw on the account, any of these persons may stop payment or close the account. A stop payment order is effective for 6 months, but it lapses after 14 calendar days if the original order was oral or was not confirmed in a record within that time period. A stop payment order may be renewed for additional 6 month periods by a record given to the bank within a period during which the stop payment order is effective. The burden of establishing the fact and amount of loss resulting from the payment of an item contrary to a stop payment order or order to close an account is on the customer. The loss from payment of an item contrary to a stop payment order may include damages or dishonor of subsequent items under Nevada statutes 104.442. 4402. You might want to look that up. The NRS 104.4403. And read those.
104. Sorry, Randy, one more time.
NRS 104.4403. Customers' right to stop payment. This doesn't really go to the bank's right to stop payment.
Yeah, yes, I was about to point that out.
The bank, you might make a mistake, but you're not a banker. Okay. Look that up. We're about to go to break here. We need to move along. Okay. Thank you, Irvin. And let us know how this works out. This is Randy Kelton, Fat Pack, Root of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Easy.
Okay,
Randy,
we are back. Go ahead. Go ahead, Vet.
I just said, Randy, where are you at?
Oh, I am here. I generally wait a few seconds for that bumper music to kind of drop down a little bit. This is, okay, we are back, and we're going to go to Alan in California. Hello, Alan. Are you there? Okay, this is a first-time caller, and it seems like when my call screener told me who it was, that I think the name was wrong. We have a first-time caller waiting to come online. It looks like we may have lost voice on him. Okay, we're going to go to Chris in Pennsylvania. Hello, Chris. Maybe we can get the call screener to check him out to see what's wrong with his line. Hello, Chris. What do you have for us today? today?
Hey, Randy, how are you?
I am good. Okay, for those who don't know who Chris is, Chris filed bankruptcy in a foreclosure proceeding, claimed the property is unsecured. The bank was unable to prove up their position. As I take it, they made no effort to prove up their position, did they?
No.
Okay, so they didn't prove up their position, so the debt was discharged in bankruptcy. And then the bank came back and tried to enforce the deed of trust. So where are we at this point?
Well, my question in what you just raised there was, is that administration or is that administering? I ran across an idle topic that Leslie actually had presented to me about bankruptcy not being given to the creditor if you file a Chapter 7 bankruptcy. And it had to do with the trustee of the bankruptcy or of the assignment not administering the debt after bankruptcy. And my question is administering a debt by the trustee something that automatically happens, or is that something that has to take place in order for the bankruptcy court to say that the debt was not unsecured and therefore dischargeable?
Well, in order for when you file bankruptcy, you're required to notice the bank, to turn over all of your assets to the trustee. And they go to the trustee in trust. Now it's the duty of the trustee to disperse your assets to the creditors. So I'm not sure what Leslie's referring to.
Well, this was a case that currently has been tried in Miami, I believe, or in the state of Florida. And the judge ruled that in a foreclosure case, if a bankruptcy is involved, that after bankruptcy, if the trustee doesn't administer whatever term that is or whatever that is, the debt, that bankruptcy code does not automatically give the creditor the property. It gives it to the borrower based on a kind of abandonment issue from the trustee not administering.
That's precisely what happened here. What happened here is you turned this property over to the trustee and you gave it to the trustee in trust. And no one came to make a claim against it. Or the ones that tried to make a claim against it couldn't support the claim. That's like me. You go into bankruptcy and I come in and say, I've got a claim against your property. And in your case, you claim the property is unsecured and you told the trustee, nobody has a claim against this property. And then the bank comes along and says, wait a minute, I got a claim against this property. And you told them to prove it up. They couldn't prove it up, so they're out of here as far as the bankruptcy court's concerned. This property is unsecured.
Administer is. When they administer, or I think that's the term they use in this case that I've been reading, is that no one administered the case. And it's kind of a controversial thing because everyone has supposedly agreed with the fact that since you give up your right to adjudicate against a foreclosure case once you've given it up on a Chapter 7, that you don't lose that right because nowhere in bankruptcy code does it say that the bank is given, the creditor is given the property. It says because no one administered it, the bank gives that right. Is that word administer what I'm looking at, or is that
what I'm thinking is the issue we're having here is context. If there is a third party creditor, then the trustee would have to administer the distribution of the asset to whatever claimant was there. But in your case, you don't have a claimant. So no one raised a valid claim against the property, so the bank discharged any claims against the property in bankruptcy.
Right.
Just like they do with credit cards. The property came up as unsecured. nobody proved up that they had a secured claim against the property, so the bankruptcy court discharged and returned the property to you with no claim against it.
Right.
If the bank had a claim against the property, they had to bring it into bankruptcy court. They can't come back later and try to adjudicate that because, what was it, 11 U.S.C. 256 or 254 specifically forbade them from adjudicating the deed of trust. But that's what they seem to be trying to do.
Right.
So I believe what the issue here is they would, the term administer would go to a situation where the property was not claimed as unsecured. And, we're the only ones who do that. Nobody else claims the property as unsecured. Lawyers won't do it.
Right.
So this is not something common out there. So I would suspect that what that's referring to is a secured debt, because that's the only thing that the bankruptcy trustee can administer.
Right. So in an unsecured debt, dischargeable in bankruptcy with no administration or administering of by the trustee, that leaves only the mortgage unsecured.
Unsecured. And you have the bankruptcy code that forbids the lender from trying to enforce an unsecured mortgage.
Right.
So where are you at in this case?
Well, we just got the letter back from the bank. My lawyer failed to put in a brief. There's two topics I have here. That was the beginning of both of them. But the topic of the lawyer failed to put in a brief along with her response to the bank claiming the summary judgment for, a motion for summary judgment. They placed that motion, and the bank received the motion, and a sheriff's sale was set up. My attorney claimed that the bank did not take the right assignment of mortgage to the judge, and when they had their argument on December, so he gave her 2 weeks to file a brief. She, in that 2 weeks, failed to file a brief, so he ruled summary judgment. And when she came back to them, she said, that's not a reason to make a summary judgment based on timing of filing a brief. There must be some reason other than that. So the judge allowed the bank to make 30 days to make a response to why we are not entitled to summary, or why we are not entitled to relief on this matter. So 30 days is up. We got the notice that the bank put in, and the bank clearly is making invalid points by raising issues of title as not being a subject matter here. The fact that they took a note endorsed in blank from no one, they haven't made a claim as to how they got the note. Normally, the mortgage assignment makes reference to the mortgage and the note being assigned to the bank. This assignment only assigned the mortgage with no indication that the note was assigned. So the mortgage...
Okay, and the mortgage does not follow... the note does not follow the mortgage. The mortgage follows the note.
The mortgage follows the note. So in this instance, with no note assignment, the bank is making a claim that they hold the original note. And I always thought it an oxymoron. If you're telling me you're endorsing a note in blank and the original mortgage was endorsed and you're making a claim to holding the original mortgage, how does anyone logically understand what you just said?
Okay. I didn't understand what you just said. Hang on. Let me pick this up on the other side. This is Randy Kelton, Yvette Mott, Root of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
Okay, we are back. Randy Kelton, Root of Law Radio, and we're talking to Chris in Pennsylvania. Okay, Chris, what is... it seems like if we're talking about assignments, the wrong issues before the court. The issue before the court should be that these guys are forbidden to try to enforce the mortgage. Oh, okay, you're unmuted. Okay.
Bankruptcy law applies there, and the judge recognizes that.
Wait, say that again. I spoke and it drove you down. I couldn't hear you.
That is, in case the bankruptcy law applies there, in that instance, where nothing has been administered and the property goes to the borrower, not the creditor, which is how the bankruptcy law rules, even though people have been ruling against that because they just assume that, the creditor is entitled to this property after a Chapter 7 bankruptcy.
And they're probably assuming that because almost everybody who files a bankruptcy, 7 or 13, they claim the property as secured. But you didn't do that. So yours is an unusual case, and the judge may be, and the other side may be looking at this from the perspective of the property being claimed as secured.
Either way, if it's claimed secured or it's not claimed secured, and no one administers it to claim that it is secured, it still would be ruled
right
dischargeable only if it's unsecured.
Yeah, the trustee would have to transfer the asset to the borrower or to the lender. The claimant in the secured, the trustee would have to transfer the property to the secured creditor. And it wasn't.
Right.
So it was discharged. So your position should be that they're subject to collateral estoppel or equitable estoppel. They had a claim, they should have brought it in the bankruptcy court.
Right.
And they didn't. So they can't come now and exercise a claim when they had ample opportunity to bring it.
Right. And that brings me back to what we discussed before we went on break, was the oxymoronic attempt to state that even a note endorsed in blank is the original when the original note was endorsed. Now, if I bring that claim to court and tell you that this note that I went down to the Recorder of Deeds office and made copy of and just omitted the endorsement and say this is the real note, that's not the case here.
Well, what does, in this context, the term original mean?
Well, that's a good question.
We may have to look that up because we're assuming that the original means the wet ink signature note. But I often create 3 or 4 originals. I'll sign 3 or 4 originals. If I have an original and I transfer that original to someone else, does that person hold an original?
No, but they hold a copy of the original as it was done originally. An endorsement in blank isn't even a copy of the original.
Well, now, wait a minute. It transfers the original claim to another person. What I'm getting at is in law, what does original mean? If you purchase a property and you get a mortgage on it, and then I come and purchase the property from you and buy the mortgage from you, and you assign the property to me, do I hold an original?
Well,
that's what they're saying, that they took possession of the property, and the instrument that provides them possession is an original instrument from their perspective. They hold an original transfer now of the original instrument. That's why I'm looking at what does original mean in this context.
Right. Well, the interesting part of that is if no claim is made to whom the party you received that from, how do you justify the fact that you received the original copy?
Okay, no claim is made. I didn't understand what that meant. If the person who did the transfer would have to be the holder of the indebtedness.
Right, so that would be the mortgagee.
So in this case, since the indebtedness was discharged in bankruptcy, there is no indebtedness.
Correct.
So regardless of what they hold, that they apparently had a claim against the property. Was their claim properly filed in the public record?
Their claim was properly filed in the public record.
Okay.
That they made a claim from Wachovia Bank, who'd been out of business for several years, and the mortgage assignment took place 3 days before they filed it, long before.
Okay. Then it's not properly filed in the public record. Have you filed a petition for quiet title on that supposed transfer?
Well, that's where we're headed with this, and we were waiting to see what the bank came back with as their response as to why we're not entitled to relief. And the main issue the bank presented was that title is not an issue here. And they used two case laws from Pennsylvania, Murray and Powell. And both of those are trumped by Limpouri, which made the best example of why title is so important in the state of Pennsylvania.
So it's your position that the law they stand on has been trumped by the law you stand on?
Correct. And that law is something I'm trying to... We have a court date. The interesting part about all of this was our court date was to be yesterday for our attorney and the bank to argue their reply. Now, there was a scheduling conflict with someone, not sure who, but the judge pushed it back to the 28th of this month, which now gives us the opportunity to get our act together to make argument to these points. And I think we discussed last time we talked about the California case, which mentioned about you're able to file against the assignment if you've been injured in this case.
Okay, well, what Ivanova said is that after foreclosure, you have standing to challenge the assignment. Now, in Tonini, the guy I'm helping, we have a case that mirrors Inova, except that in Rick's case, foreclosure hasn't been completed. It's been initiated, but it hasn't been completed. And what we've brought, and it stopped the court in their tracks because they asked for a letter brief showing how Inova affected this case. And what we claimed was that the San Diego court needed to distinguish Inova because Inova said that after foreclosure, you have a right to challenge an assignment. But the Inova case was initiated after foreclosure. We're saying that if there is an assignment and a note is in good standing, the assignment has no effect on the borrower. But once the assignee files a notice of acceleration in the public record, now the borrower has been harmed because his credit has been affected, his reputation has been affected. The borrower has now been subjected to harm. So the question becomes, how does my harm change from the point of the notice of acceleration until eviction?
Correct.
If I have a claim at the beginning, I have a claim at the end, I should have a claim all the way through. It's unreasonable to ask me to wait until I'm evicted from the property to file a claim against the person who's trying to evict me. So we asked them to distinguish Inova and distinguish it by defining after foreclosure to mean after initiation of foreclosure. And another similar case has been picked up by the Supreme, and this San Diego court seems to be waiting for that case to be filed. But essentially what it says is, once they foreclose, now you can challenge the assignment.
Right.
I mean, as far as your position in Pennsylvania is concerned.
Right. From my understanding, speaking with Leslie today, we had a discussion about this. And from my understanding, what she's been telling me is that a mortgage state, you can file anytime when you're in foreclosure. In a deed of trust state, you have to wait until the foreclosure is finished.
I don't know where she got that distinction, because Inova certainly didn't make that distinction.
Right.
And I haven't. Inova was unique because that particular issue, we couldn't find it specifically being addressed elsewhere.
Okay.
So maybe your lawyer has some Pennsylvania case law addressing that, but I've never seen a difference in that regard between a deed of trust and a mortgage state.
Okay.
So there may be. It's just it's not a question that I've ever had come up before.
Right. Is California a deed of trust state?
Yes, it is.
Okay.
But this, as far as mortgage or deed of trust, this shouldn't make any difference because this merely goes to a claim against the property. And the only difference between a deed of trust state is the confessed judgment. So the claim is still the claim. And the question was, when can you make the claim? Hang on, Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number, 512-646-1984. I'm having trouble getting used to doing both names, but I'll get that. Okay, we'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took money from my hand. Ain't gonna fool me with that same old trick again.
Okay, we are back. Randy Kelton, Rule of Law Radio. This is Randy Kelton and Yvette Pack, and Yvette Pack, his name is Yvette Motley Pack. So I think we're going to start calling this the two of us the Motley Pack. Anyway, we're talking to Chris in Pennsylvania. Okay, Chris, I'm having trouble with where you're at in the case and why you're at this point. Is this an argument that you're putting in and you have other arguments in the alternative? So, this is not something on which the case is going to resolve, is it?
No, this is merely the case has been moved to the 28th for argument based on what the bank replied to as why we're not entitled to relief. And everything we've just talked about, the bank mentions why we're not entitled to relief. They also mentioned that we can't attest to standing of the assignment of the parties in the assignment base because we have not been injured in this case, which is quite the contrary because they've foreclosed on us and have a sheriff's sale. We've been injured as far as we can be injured.
Yeah, I would ask the other side to define what it means by the term injured. And I think their definition is you've only been required to honor the contract. So that's not an injury. And you're saying, but I wasn't required to honor the contract to you. So it is an injury.
Right. The bank is also making a statement in their response that they say it doesn't matter that they have mentioned that Fannie Mae is the owner of this as a third party to prove title that they've come about this note when they've taken an assignment from Wachovia. And my theory was that the mortgage follows the note, and the assignment of mortgage and note has to be from that same person who's assigning the mortgage.
That's Carpenter Longan. So if they're moving the mortgage around and not the note, then they've separated the mortgage from the note. So who actually holds the note? Oh, wait, nobody holds the note.
Right.
It's been discharged.
No,
this really doesn't make sense. And I suspect that you're in the process of arguing interim issues that will, in the end, be minor points. The real issue is going to be, does the discharge have any force and effect?
Right.
Yeah. Okay.
Which brings me to my last point, which is if my attorney never filed a brief raising these issues, okay, and this is what the bank is making in their reply, they've spent 2 paragraphs talking about how my attorney had timely due process to file a response and never did. Okay? The recourse toward my lawyer for if this gets adjudicated that her not filing a brief is the reason I lose this mortgage.
Then you have a claim against your lawyer. And your lawyer's probably pretty worried about this. This is the kind of thing that gets lawyers sued.
Well, that's probably why she hasn't asked me for any money in a while.
Yeah, she's probably terrified that that she's going to lose this, and then you're going to sue her. And that's appropriate. That's what malpractice is for. You go to a lawyer, and he's going to look around for deep pockets. So you look around for deep pockets. This lawyer's got malpractice insurance. So if you lose it to the bank, you got a shot at the lawyer.
How easily is that done?
Wait, say that again?
It's already been adjudicated.
Well, once you get a final adjudication, if you lose, and you lose because the lawyer failed to file the brief, it's clearly a fault on part of the lawyer, then the lawyer is responsible for your loss. So once you get a final adjudication, then you just go back and sue your lawyer.
And that should be pretty simple since it's already collateral estoppel.
Yeah, that's a pretty straightforward suit. And what the insurance company will do will probably make a deal with you. So, that's for you, that's probably a good thing.
Well, I'm trying to weigh all my options here, It appears as though if she can make this final argument in favor of what we've just discussed, it'll open us up to be able to ask to place this quiet title and finally come to terms with the gambit of who's actually the lender. The bank's making the claim they're the servicer. They've sent us 20 letters claiming they're the servicer for Fannie Mae, who's the lender. We have Fannie Mae making a claim on our credit report that the debt has been discharged under Chapter 7 with no assignment of mortgage. No, they're not involved with the note or the mortgage. How do they make that claim? That's a Fair Credit Reporting Act violation. How does the bank actually make that claim when they've taken the assignment of the construction loan and not the mortgage? And they're saying that's not a big deal in their response because they hold the note, which they haven't established as to how they got this note with all these people involved.
Yeah, but the note has been discharged. So they hold a note with no value.
Right, and the note was discharged before they went to court for the foreclosure.
So most likely they get past this issue, then they're still going. The bank still has a large hurdle to overcome.
And the statute of limitations runs out in about 8 months.
No, if they're in court, the statute of limitations doesn't run anymore. Unless they're dismissed completely. If they're dismissed, then they're out of time. If you get a dismissal, then it's like the suit never happened. So then the statute of limitations are running for the purpose of a dismissal. But if you're in court with them, they can stay in court 10 years. Statute of limitations doesn't matter.
Okay.
Yeah, the only time it'll matter if you get a dismissal. Okay. Anything else?
Okay. No, that was perfect. Thanks. Just wanted to give you an update on where I was with this, and hopefully on the 28th we'll figure out how this gets adjudicated.
Let us know how this works out. I'd be interested in hearing it. Oh, yeah, and next Friday be the 29th. That'll be perfect.
Yeah.
Okay.
I'll let you know.
Okay, thank you, Chris. Now we're going to go to Alan in California. Hello, Alan. Last time we couldn't hear you. Are you there now?
Must be talking to me.
Much better.
Are you talking to me?
Yeah, I'm talking to you, yes.
My name is Phil, and I'm in South Carolina.
Oh, okay. Yeah, I thought my producer told me that somehow the database brought up the wrong name here.
Well, I'm calling over Skype. That's probably why.
Okay. What do you have for us today?
I want to switch the subject up to transportation. I know this is Eddie Craig's forte, but I want you to see if you could give me your take on a federal statute has to do with uniformity regulation.
Okay, hang on. We're about to go to break. We'll pick this up on the other side. This is Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Getting hitched may be one of the best moves a man can make, according to new research about the health benefits of marriage. I'm Dr. Catherine Albrecht. I'll be back in just a moment to tell you why men should be grateful for their wives.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Married men live longer, healthier lives than single men. For example, they have a lower risk of depression, they're more likely to survive a bout with cancer, and they have a 46% lower chance of dying from heart disease. Why is that? A study by the RAND Corporation suggests that a big reason is their overall healthier lifestyle. Married men are better cared for when they're sick, have healthier diets, and have far less stress in a happy home environment. They're also less likely to smoke, drink excessively, or engage in other risky behaviors. So, despite all those jokes about married life, men, you should be grateful for that proverbial ball and chain. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Vet Mott, Voodoo Law Radio. I'll get this straight in a minute. I'm still having trouble getting the name right. Her name is Vet Motley Pack. And I keep wanting to say Vet Mott for some reason. So anyway, Vet Pack, she's going to beat the crap out of me. She's 5'2", 110 pounds. And she sent me a video of her in one of these weight machines on her back with her legs pressing 430 pounds. I sent her a text back, said, that's nothing. I could press a third of that. She has muscles in places where I don't have places. She's a black belt in karate. This woman is incredible. So now when we travel around the country, if we're doing seminars, now I have my own bodyguard. Okay. Where are we, Alan?
Okay. Still. And there's a transportation code, federal transportation code, Title 49, I believe it is, and it's Section 30103. It has to do with uniformity of regulation. Now, I've been listening to Eddie and yourself and some others and how people's God-given liberties are being translated into privileges for the benefit of those who are receiving money, and I begin to want to fight back against it. And I've been trying to do some reading, and the work that y'all do is awesome beyond words because you add an offensive component where a lot of people just go in on the defense. And this regulation seems to say that states, because all of the states, I believe, have had to adopt the Federal Transportation Code in order to have uniformity across the country.
Okay, hold on. They haven't had to. The feds encouraged them to. And the same thing with the penal code and most all of the penal and transportation. They encouraged them to. The feds put together a set of uniform codes. And I think all of the states but 3 adopted them.
Okay.
And then those states, since they adopted the code, they can do anything they want to do with it. So the state can still make adjustments to the code. This provision in the federal code is not controlling on the states. It's only advisory. Okay, go ahead.
It says in that a state may enforce a standard that's identical to a standard that's prescribed under this chapter. I don't know whether that imposed an absolute on the states or not, but like you said, it wouldn't.
No, they didn't because they couldn't. That would be an undue preemption of state sovereignty. So all they could do was suggest that they do and try to get them to. Most of them did. so that if I leave Texas and I go to South Carolina, I pretty well understand what the law is, but they're not required to.
Okay. Another thing about regulation. It seems that most of the agencies are not following their regulations to the letter like they're supposed to. From what my understanding of the Supreme Court, I think the case is U.S. versus EFNA, where they were supposed to follow their regulations scrupulously, or their actions won't stand. In South Carolina, the Department of Public Safety has regulations with outlining their jurisdiction, and it stated that the authorization for their rules came from the state laws concerning motor vehicle carriers. And the jurisdiction was for motor carriers for hire. These are the exact words in the regulation. But then they have what seems to be a regulation which would let them get away with not following the previous regulation. And the exact words is, the adoption of these rules shall in no way preclude the department from altering, amending, or revoking them in whole or in part, or from requiring any other additional service, equipment, facility, yada, yada, yada.
Okay. Well, they had to put that in there in order to keep from preempting state law. See, that's the caveat. Is whatever, but in the end, the first part about them having to follow the law scrupulously, well, that goes to due process. That goes to federal due process, and they can require that they follow the law scrupulously. But they can change local law and adjust it from the model standards that the feds produced.
These are just for the rules, I'm saying. For the rules and regulations for the department.
Yeah.
They seem to be really able to waive these rules or whatever they want to do if it becomes inconvenient for them.
Well, they have to follow they can change the rules, but they have to follow those rules scrupulously. They can't just arbitrarily and capriciously change the rules to fit a circumstance.
I see. Okay, well, this rule about this jurisdiction says it for a general application and applies to any person, firm, partnership, you know how the language goes, become engaged as a motor carrier for hire within a state. And this is under jurisdiction. It's written into their regulations. And these regulations were they were promulgated by the enactments from the General Assembly of the state. So it comes from law that the Motor Carrier Act. They don't follow it when they stop a person on the street.
Okay, that almost exactly mirrors Texas law. And I suspect it's going to pretty well mirror every state in the union, because clearly they're licensing a profession because they can't license a right. The problem is, for us, is we have to make the right argument in order to get the right answer. And I generally don't do traffic, but I have seen a lot of people who are trying to do traffic, and the problems I tend to see come from some unwarranted presuppositions. And it's not straightforward as to why most people are losing. The presupposition is that the law is necessarily controlling, and it's not. The law only controls if you bring the law before the court, and you have to bring it in before the court in a way that they can't get past it. Eddie doesn't like this, but I am registered with the Federal Department of Transportation as a motor carrier.
Okay.
Not exactly. I'm sorry. I said as a motor carrier. I am registered under the Motor Carrier Act as a private operator, not in commerce. So while I'm registered with the Department of Transportation, every time a policeman pulls me over, I said, "Did you check with the Department of Transportation for my registration there?" And they always say, "Well, no." I said, well, you might want to do that, because that gives them public notice that I'm a private operator, not in commerce. So I can have my license, and have it on my vehicle, and I have the right to operate in commerce, but I've registered myself with the DOT as a private operator. And this is put in there in it for a case where, say, you own a farm, a large farm, and you haul your own product to market. Well, all of these big trucks, hold on, I think we're about to go to break. Yeah. Okay, we'll pick this up on the other side, but this is Randy Kelton, Vet Pack, Root of Law Radio. Our call-in number 512-646-1984. We'll pick this up on the other side, and I'll get used to this new name set eventually. We'll be right back.
Well, you know, karma is lurking around the corner. You better watch every step you take. And good and good to follow you. Yeah, but Jerry, sing reality. Okay, karma is lurking around the corner. Sing, Jerry, come.
As we sow, so shall we reap.
Okay, we are back. Randy Kelton, Vet Pack, Root of Law Radio, and we're talking to Phil in South Carolina. There's something I'm trying to find a way to explain it. I had a guy in court just today, in a traffic court, and I'm thinking about how do I force the court to this issue? They don't want to go to this issue. So how do I force them to the issue? And one of the things I was thinking, when the prosecutor brings the police officer up on the stand, the first thing he does is establishes the officer's credentials. So he starts asking him about his credentials as a peace officer, and I'm thinking I want to object, relevance. And they're going to get all excited. Well, he's a police officer, blah, blah, blah. Objection, relevance. What does that have to do with enforcing the traffic code? The peace officer is authorized to enforce the criminal laws, but the transportation code takes a special authorization. Will you demonstrate his authorization to enforce the traffic code or the transportation code? That's why I'm trying to work a way to push to bring these issues before the court. I'm not sure, we have some peculiar stuff in Texas that goes to who can enforce the traffic code. Phil, have you looked at it'll probably be in your administrative code that creates where the transportation code is implemented. Ours says that the sheriff of the county can appoint 5 officers to enforce the transportation code. And these officers have to be certified by the Department of Transportation. And then it lists who can be certified. So the sheriff doesn't have to select only sheriff's deputies. He can select any peace officer in the county so long as the peace officer is from a city with a population more than a certain amount, in a county with a national highway or bordering a Mexican state. It's got this whole section of the most outrageous conditions you ever heard of. Have you found anything like that in South Carolina?
Well, unfortunately, South Carolina is kind of Spartan in their legislation. I've been listening to your show and digging through your archives, and your Texas Code of Criminal Code is almost as large as the entire legislation of South Carolina. Is huge. And South Carolina Criminal Code, it's Spartan, to say the least. It doesn't cover anything. And we have to go through the entire code, and we have to go through the regulations for the individual departments to find out where their authority comes from. And like I was saying, here in the regulations for the Department of Public Safety, the General Assembly has gone through another title.
The implementation of the regulations, that's a place almost nobody goes. And that was one of the big advantages that Eddie Craig gave us, because he went back to the beginning and he wanted to know how these guys got their authority. And what he found was absolutely amazing. So it may be worth the time, because it's not really that, the implementation portion is not going to be that great. And a few good internet searches should help you find it. What constitutes law? How is law enacted? How was the Transportation Code enacted? And we have the Transportation Code in Texas, but we also have the Administrative Code, which sets up the Department of Public Safety and grants them their authorities. You're going to have the same thing in South Carolina, and it should be right in the beginning of the section that addresses the Department of Public Safety. Because they're the traffic cops. And then
here in South Carolina, this is established under the Motor Vehicle Code. It's established under the statutes.
And that's okay. Well, in Texas, it's just a different place. They just stuck it in the Motor Vehicle Code. Texas adopted the Federal Transportation Code. Okay. They adopted it in total. So when they set up all these implementations, they did that in the Administrative Code rather than mess with the Transportation Code. It looks like South Carolina kind of weaved them together, but it should be in the front. Authorization. You read that real careful, and the first thing you want to talk to the court about is, how do you get jurisdiction? You have this officer here who comes to the court and makes an accusation of a violation of this code. And the first thing I want to know is, who is this guy? And how did this guy accrue the legal capacity to invoke the subject matter jurisdiction of the court? We're filing challenges to subject matter jurisdiction, and the judges simply don't understand it. They're saying, this is ludicrous. Of course I have jurisdiction. And we're saying, no. We're not challenging the general jurisdiction of the court itself. We're challenging the capacity of the complainant to invoke your jurisdiction. So we're saying this officer who came to the court and made an accusation of violation of the Transportation Code does not have the power to file an allegation of a violation. Have you looked at that part? What kind of certification does an officer have to have? Okay, here's what happened in Texas. They set this up primarily for the Department of Public Safety to enforce the traffic code. The Department of Public Safety was created for that purpose. So your Department of Public Safety, since yours is called Department of Public Safety, good chance it was set up the same way. The DPS looks like state police, but they're really not. And this is something to look for. A Department of Public Safety officer in Texas is a police officer. A county sheriff's deputy is a peace officer.
Right.
And you understand the difference. Or for those who don't, in Texas law, a police officer is someone authorized to enforce the traffic code. Now, that person can be a certified peace officer. And all Department of Public Safety officers are certified peace officers. But they are not employed in the capacity of a peace officer. They're employed in the capacity of a police officer. Now, a peace officer can enforce the traffic code if he meets certain requirements. Then he can enforce both. In our law, it says the Department of Public Safety shall not enforce the criminal laws except at the request of and under the direction of local law enforcement. They're strictly forbidden. They do it anyway, but the statute forbids them to. So they're police officers. Regular cops are peace officers. Good chance in South Carolina you have a similar distinction. Look for that. What they're thinking is the DOT cop. The DOT guy who goes out and inspects these big trucks and checks their weight and checks, that they meet all of the requirements. That's who they're really thinking about. And they're saying that the sheriff can appoint 5 guys to do this. And they have to go to the Department of Public Safety and get certified. So they teach them how to check out all these trucks. Well, now they're taking the same enforcement and applying it to people that are not in commerce. So They set it up for one thing and they're using it for something else. I bet South Carolina did the same thing.
All of them are doing it.
Yes. So the place to take them on is never on the merits.
Right.
The place to take them on is on the jurisdiction.
Always.
Yeah, the good thing about subject matter jurisdiction. The only time you can sue a judge is when he lacks subject matter jurisdiction. Judge McBride here in Fort Worth, this federal judge who's such a stinker and everybody hates and afraid of, I'm about to sue him because he dismissed my case on a Rule 12 when there was a challenge to subject matter jurisdiction he didn't answer. Gotcha. No subject matter jurisdiction, no immunity from suit. So you always want a subject matter jurisdiction challenge. And I think I've kind of taken this over and haven't really let you ask the questions that you wanted to ask. That's why I got a co-host. She needs to kick me in the pants and tell me to shut up. Okay, when we come back on the other side, Alan, I'm going to shut my mouth and let you ask your questions or make your comments. This is Randy Kelton, Vet Pack Blah Radio. Our call-in number 512-646-1984. And we're going to the top of the hour, so now's a good time to go check out our sponsors and help us support this radio station. We all kind of pay for it out of our own pockets, and our pockets are getting kind of shallow. Okay, hang on. We'll be right back.